In this PowerPoint presentation from Delhi Law Academy on the Constitution of India, we shall make a serious attempt to learn certain fundamental and subtle aspects of the fundamental rights as incorporated in Part 3. Part 3 is undoubtedly the most significant provision of our Constitution. Of the fundamental rights, the right to constitutional remedies as contained in Article 32 was termed by Dr. B.R. Ambedkar as the heart and soul of our Constitution. Fundamental rights were inspired by the Bill of Rights of the US Constitution, as also by the Universal Declaration of Human Rights, as declared by the United Nations General Assembly on December 10, 1948. The fundamental rights as incorporated in Part 3 were inspired by Bill of Rights and also by the UDHR. While some of these fundamental rights are available only to Indian citizens, others are available to every person, including corporations and foreign nationals. Examples of those fundamental rights which are available only to Indian citizens: the rights contained in Article 15, 16, 19, 29, 30. Those fundamental rights which are available to all persons are contained in Articles 14, 20, 21, 25 and 32. What is so sacrosanct about the fundamental rights? The fundamental rights are protected in a special way by Article 13 of our Constitution. This article protects the rights from not only the legislative encroachment but also from executive encroachment. This article further declares that any legislative and executive encroachment will be null and void, and the statutory provisions of this article as contained in clauses 1 and 2 are as follow. Clause 1. All existing laws shall be void to the extent they are inconsistent with this part. Existing laws are those laws which were in force at the time when the Constitution came into force on 26th of January 1950. Pre-constitutional laws. Clause 1 declares that all these laws will be void to the extent they are inconsistent with Part 3. Not completely void, void only to the extent they are inconsistent with Part 3. Clause 2 talks about post-constitutional laws. This clause prohibits the state from making any law which takes away or abridges any of the rights conferred by Part 3. State is defined in Article 12 and the term law is defined in Clause 3 of this article. By Clause 2, the state is prohibited from making any law which takes away or abridges fundamental rights. What happens if the state defies this prohibition and makes such a law? Clause 2 declares such law to be void to the extent it takes away or abridges any of these rights. It needs to be noticed here that a law made in violation of Clause 2 is not completely void. It is void only to the extent it takes away or abridges the fundamental right concerned. Now we will consider the scope and effect of Article 13. As far as pre-constitutional laws are concerned, Clause 1 of Article 13 declares them to be void to the extent of inconsistency with fundamental rights. This means that the law is not void completely or in toto. It is not void for all purposes. It is also not void for all times, nor is it void for all persons. But it is void only to the extent of inconsistency with any of the fundamental rights. Such pre-constitutional laws existed for all past transactions, that is the transactions which took place before the 26th of January 1950, and these laws continued in force even after the commencement of the Constitution with respect to those persons who could not claim the concerned fundamental right. We have already seen that some fundamental rights are available only to the citizens. In case a pre-constitutional law violates any of such fundamental rights, then it will continue to apply to foreign nationals, it will continue to apply to corporations, etc. To the extent that it applies to citizens of India, it will become void. Next, we come to the scope and effect of Article 13 on post-constitutional laws. The relevant provision is Clause 2 of Article 13, and that clause once again declares such laws to be void to the extent they take away or abridge fundamental rights. Such a law shall be operative with respect to those persons who cannot claim the concerned fundamental right. Once again, the same thing. If the concerned fundamental right is available only to the citizens, then the law which violates this fundamental right will definitely be operative against non-citizens. In other words, if the fundamental right in question is available only to citizens, then this law is not void in respect of corporations and foreign nationals. It is not void in respect of them. It is applicable to them. We have already seen that a law declared void by Clause 1 or Clause 2 of Article 13 is actually not completely void. It is not void with respect to all persons. It is not void with respect for all purposes. The next question we need to answer is, will it be void for all times to come? In other words, a law which is declared void by Article 13, Clause 1 and Clause 2, can it ever be revived? Is it dead for all time to come, or can it be revived? Can it be operative in some future point of time? This question has been answered by the Supreme Court by applying the doctrine of eclipse. Eclipse occurs when one object casts its shadow over another. A law which abridges a fundamental right is not a nullity, but it remains inoperative till the shadow of the fundamental right falls over such law. Now we are talking with reference to time. It remains operative till what time? It remains operative till the time the shadow of the fundamental right continues falling over the law. And once the shadow is removed, the law will become operative. The fundamental right is overshadowing this law, and it makes it inoperative as long as this law continues violating the fundamental right. But this law can revive. It is not dead forever. It can revive if the shadow cast by the fundamental right is removed. But how to remove this shadow? Can this shadow be ever removed? The answer is in yes. This can happen. The shadow can be removed. How? The shadow can be removed if the concerned fundamental right is diluted or is completely taken away by a constitutional amendment. Like it happened in the case of the fundamental right to property, which was first diluted successively by various constitutional amendments, and finally it was taken away completely by the 44th Amendment Act in 1978. We now consider a concrete case decided by the Supreme Court where the doctrine of eclipse was applied to an existing law. This was the case of Bikaji Narayan Dhakras versus State of MP. The law in question in this case was an existing law in the year 1950. The concerned law was Central Provinces and Berar Motor Vehicles Amendment Act of 47. And the fundamental right in question in this case was the right to carry on any occupation, trade or business conferred by Article 19(1)(g) as controlled by Clause G of Article 19. The impugned act, the CP and Berar Amendment Act of 1947, it was an existing law at the time when the Constitution came into force. This existing law imposed on the exercise of the right guaranteed to the citizens of India by Article 19(1)(g) certain restrictions. This existing law, which was enacted in 1947, imposed certain restrictions on the right guaranteed to citizens of India by Article 19(1)(g). The court is saying that these restrictions could not be justified as reasonable under Clause 6 as it then stood, and consequently this existing law became void to the extent of such inconsistency by virtue of Article 13 Clause 1. Since the restrictions imposed by this law were not justified as reasonable under 19(6), therefore this law became void to the extent of inconsistency. But as we saw earlier, this law became void not completely, not for all purposes, and not for all times. It became void only to the extent it became inconsistent with the provisions of Article 19(1)(g). It did not become void independently of the existence of this fundamental right. Now it so happened that on 18th of June 1951, the Constitution First Amendment Act was passed, and through this amendment, Clause 6 of Article 19 was amended. After the amendment of Clause 6 on 18th of June 1951, the impugned act ceased to be unconstitutional. Why? Because the restrictions which were imposed by this Act of 1947 were in consonance with the restrictions permissible under Clause 6, under the amended Clause 6, and therefore this Act, which had become void to that extent, to the extent of inconsistency, now became revivified and enforceable against citizens as well as against non-citizens. It needs to be noted here that it was already operational against non-citizens even after the commencement of the Constitution, because the right in question, that is the right granted by 19(1)(g), was applicable only to citizens. So as far as non-citizens were concerned, it continued to apply even after 26th of January 1950. But once the amendment to clause 6 took place in 1951. This act became applicable even to the citizens. And now comes the doctrine of eclipse. The Supreme Court says that the true position is that the impugned law became eclipsed for the time being by the fundamental rights. Eclipsed for the time being, only for some time. And the effect of the Constitution First Amendment Act 1951 was to remove this shadow, was to remove the shadow of the fundamental right and to make the impugned act free from all blemish or infirmity. The First Amendment Act removed the shadow of the fundamental right which was cast on this 1947 law. So, what was the effect? Between 26th of January 1950 and 18th of June 1951, the impugned act remained in a dormant or moribund condition, that is, it remained eclipsed. But it remained eclipsed only as far as citizens are concerned. It continued to be operative as against non-citizens. This was the position up to 18th June. But after 18th June of 1951, this law became revivified and enforceable even against citizens. The shadow of the fundamental right was removed, the eclipse was over, and the law became operational against citizens as well as against non-citizens. So this in a sense is the doctrine of eclipse.